This is Anthony Sebok, professor of law at the Cardozo School of Law in New York City, to discuss Tarasoff versus Regents of the University of California. Welcome, Professor Sebok.
Thank you. Thank you for having me. So I thought I'd start off by giving a very brief description of this lawsuit. And the lawsuit probably is, or the case is probably one of the most important cases that come out of the civil justice system in the following sense. There is no doubt that this case, if not change the behavior of an entire class of professionals, it certainly helped clarify what they should be doing in a way that you can measure. You can measure it in at least two ways. Anyone who has been trained as a mental health professional has been told about this case by name. And also, you can see that there's been a lot of scholarship outside of the law schools where people in the mental health professions, academics in psychology, psychiatry, have been trying to determine whether or not the conduct required by this case has made a difference, not just in how psychologists and psychiatrists behave, but also in whether or not society is more at risk or less at risk of violent behavior. So this is a case that really goes outside of just tort law, really goes outside of even just the world of lawyers. This is a case that definitely overlaps in very concrete ways with a community outside of law. And for that reason, I think it's very interesting, because rarely do I feel, as someone who works in law, that the things I do are known and understood by people outside of my field as well as I understand it. So when I talk to friends of mine who are therapists, they know this case, and they talk about it with a kind of authority that goes beyond what I could even say about it as someone who teaches it in an introductory first-year course. So this case, it arises on New Year's Eve in 1968 in the Bay Area, and it's a tragic case. It's a case involving the murder, an acquaintance murder, a murder by a man who was an acquaintance of the victim. It arises on New Year's Eve when these two people met. I actually think that only one of them was a student at the University of California. I don't believe that the victim was a student at the University of California, but they met at a party on campus at the International House, and Prosejit Hodar, who had come to the United States to study naval architecture from South Asia, met Tatiana Tarasoff, who was a person living and growing up both in Brazil and in the Bay Area. They had a kind of friendly interaction. The details are not that important, but they certainly acted in a way that would lead people to think that maybe that there was a romantic interaction. In any event, Tarasoff, the victim, quickly clarified to Hodar, the person who did the killing, that she wasn't interested in him, but they stayed friends. Like, one of the sort of odd things about this case, sad things about this case, is just how much the sort of familiarity between the parties, as so often happens, created conditions under which the murder could occur. So she made it clear that she didn't want a romantic relationship. He did not understand or accept this, perhaps because of an underlying mental illness that he had. And in any event, she went away for the summer to go back visit relatives in Brazil, and he was despondent. He was seeing, at that point, a mental health professional at the University Health Center. He was seeing a therapist named Lawrence Moore. And when she came back at the end of the summer, back into the Bay Area, Hodar grew violently jealous of her dating other people, and he told his therapist, he told Lawrence Moore, that he wanted to kill a woman named Tatiana Tarasoff. And Moore immediately reported this to his supervisor. The supervisor at the clinic immediately reported to campus police. Campus police picked up uh, Podar. They did not keep him. They concluded that he was not a threat from the perspective of whether or not involuntary commitment should be instituted by the police. The clinic where Moore worked did not take any further steps. They, in fact, took the further step of destroying all communication between them and the police that would have been going into a file. Why they did so is not clear. It was not in order at that point, I think, to avoid liability. It was simply perhaps a concern about privacy concerns they had about those documents getting out, because at that time they were under the impression that the police had drawn a conclusion that they would not involuntarily detain Podar, and they had not drawn the conclusion that Podar should be involuntarily detained. Podar then, within 2 weeks, murdered Tatiana Tarasoff. And a lawsuit was initiated, and the lawsuit was against the University of California campus security cops, the police, as employees of the University of California, and against the mental health professionals, all of them, including Lawrence Moore and his supervisor, for essentially doing something wrong that caused the death. Now, of course, there was a criminal proceeding as well against Podar, and that criminal proceeding followed its own interesting pathway. It also became an important case in front of the California Supreme Court involving the insanity defense, but that's a completely separate issue that I'm not going to be talking about right now. So that's the background of the case. I don't know whether you want me to tell you any more about what happened, except I'll just say this. The trial judge dismissed all of the claims, basically as a matter of law, saying that regardless of the allegations of fact, very few of which were in controversy, there was no basis for a wrongful death claim to be brought by Tarasoff's family, because there was no legal duty owed by any of the defendants employed by the University of California. None of these individual defendants or their employer owed a duty to have done anything with regard to her well-being, and therefore whatever they did, whether it was done carefully or carelessly, is irrelevant because they owed no duty to do it carefully, and that was the issue that went up on appeal to the California Supreme Court.
All right. And then what was the outcome? And then we'll talk about why it's such a groundbreaking decision.
Well, the outcome, so this case was decided in 1976. It took many, many years from the death in 69 to make it up to the California Supreme Court. It actually went back and forth twice. There's a Tarasoff 1 and a Tarasoff 2. But Tarasoff 2, which is the 76 decision, is the one that I'll talk about. The outcome was that a majority of the California Supreme Court, over some different dissents, which I can talk about, or a concurrence and a dissent, came to the conclusion that of the four chief claims of duty made by Tarasoff's family, three of them, the trial judge was right. There was no duty, but in one of the four, there was a duty. So basically, as against the police officers, the trial judge said that even before I get to the question of duty, on the question of sovereign immunity here, the police officers acted within the scope of their discretionary function, and therefore, even if there had been a duty, they are immune from lawsuit because of sovereign immunity. The court also concluded the police officers had never actually initiated a rescue and therefore had no obligation to perform a rescue carefully. And as regard to the mental health professionals, similarly, there was no actionable claim for confinement, because again, that would have been a matter that would have been taken off the table by sovereign immunity. But the one thing that did not get taken off the table by sovereign immunity was a common law duty to take reasonable steps, not to confine Podar, but to protect Tatiana by doing something such as picking up the phone and calling her, or picking up the phone and calling someone who knew her and warning her. Now, I want to make it clear that the final holding of this case is not that there's a duty to warn. Some people say that there is a duty to warn. That is the bottom line. That is the black letter rule of the famous Tarasoff case. And actually, that's not correct. There is a duty to take reasonable steps to protect a third party, to protect the plaintiff, the victim, if the mental health professional has knowledge or is reason to believe that a patient poses a serious risk of injury to that victim. There is a duty to take reasonable steps. And often the reasonable step that people are thinking about is a phone call. But it doesn't have to be a phone call. It could also be, for example, alerting other people who could initiate, for example, outpatient treatment or things like that. So that was the holding.
And what makes this an evolution in the law of psychotherapy or physician-patient relations? Why is this a change in the landscape?
Well, so research of academics who've studied the impact of Tarasoff, or who have studied the reception of Tarasoff, have discovered that by surveys that mental health professionals in and around the Tarasoff decision overwhelmingly thought that they were free, they were not bound by concerns of privacy to warn someone like Tarasoff if they wanted to. So the question is not so much whether or not this changed, and it really couldn't change because it would be a matter of state law in terms of privacy law. The question is not whether or not it changed the beliefs of whether or not a mental health professional was at liberty to take a step to make a phone call like this. They all thought they had that liberty anyway. The only thing that it changed was whether or not they now were under an obligation. And the thing which we don't know, what we don't know from any of these surveys, is before this decision, if people were under a liberty, were they exercising that liberty? And if they weren't, whether this decision increased the number of episodes where doctors or where therapists were picking up the phone and making a call. And logic tells us that given the response that people have when they are confronted with a well-publicized new rule of liability, that they probably would view what was once permissive as now mandatory. But what we don't know, and this is the hardest thing, is we don't know how often the mandatory requirement would actually arise, because it's really hard to know just how often these defendants, these potential defendants who are these therapists, have before them a credible opportunity to warn someone of a threat to their lives. It could be a handful of events. It could be 10, 20 maybe in the whole country in any given year. Nobody knows how often the opportunity to respond to a new mandatory rule actually comes up. So what we do know is that what was once permissive is now mandatory. What we don't know is whether or not that really changes behavior very much, because we just don't know how often the opportunity arises. So that's one way of answering your question. Another way of answering your question is, it certainly has a sort of an impact in terms of the way that mental health professionals viewed the law. Because probably until this decision, mental health professionals often saw themselves as allies and as partners in the work of lawyers with regard to the needs of people interacting with the mental health system. There was a sense that mental health professionals understood that there would sometimes be in an adversarial relationship with lawyers in the deinstitutionalization context. They didn't like it when activist lawyers brought lawsuits in the 60s to sort of deinstitutionalize. They also did like it when activist lawyers, especially in the criminal justice system, employed them or asked them to help them in terms of trying to humanize their clients or to bring up facts about their mental health conditions of their clients that would perhaps inform a jury in terms of punishment or in terms of guilt in a criminal case. But what I think mental health professionals had never really thought about before is that they would be in the same position as, say, regular physicians of being the object of the equivalent of a malpractice claim. You don't have too many direct malpractice claims against mental health professionals, although you have a handful of cases which arise now with regard to failure, for example, to adequately aid, to adequately ascertain whether or not there is a real or not real repressed memory. There's a handful of lawsuits like that now brought by people who've been accused of being abusers by their children. There's a handful of suits in the 90s and recently like that. But really, unlike obstetricians or unlike other physicians, mental health professionals don't get sued in malpractice too often. However, what this was the first time I think mental health professionals felt that their performance in their competency would be the object of an adverse legal proceeding attacking whether or not what they were doing was incompetent or competent, because the argument here is that you have a duty, not necessarily to your patient, but to the person who your patient might harm, to do something, and you haven't done it. And I don't think mental health professionals thought that they would ever be in the crosshairs of the plaintiff's bar. And I think that actually kind of slightly poisoned a little bit the relationship between this particular part of the health profession and the trial bar.
And what triggers this duty? In other, if a patient comes in and says, "I hate all the left-handed people in the world," there's no identifiable person there. When is the duty to notify or to intervene or to do something triggered on the part of the therapist?
Yeah, so you've put your finger on a pretty clear and easily, I think, defined feature of the doctrine. So first of all, I should say directly to your question is the majority of jurisdictions who have adopted this duty after Tarasoff have used language like an identifiable person. It need not necessarily be a proper name. It could be a person who is easily identified. I was just looking at a case that came out of the Pennsylvania Supreme Court this year, where the question was whether or not it would be sufficient to say that one wanted to commit violent acts in a housing unit. I believe it was a housing unit. It was just in general we would call it an apartment house, an identifiable geographic region of a building with many, many units. And the Pennsylvania Supreme Court said that is not enough. If you say I'm going to go back to this apartment complex and I'm going to do something violent, that does not create a duty to act, a duty to do anything. But if the potential victim is identifiable within a much more narrow set of coordinates, if it's a name or a person who is identified as my former paramour, my former boss, my neighbor even, that's different from saying people in this apartment house. So that's the simple answer to your question. I mean, I was going to actually mention that the California Supreme Court's decision was based on doctrines that had already been codified in the second restatement of torts, but those sections were a little confusing about whether or not it would be about a duty to rescue or a duty to control. These are two different ideas. Rescue and control are quite different in everyday language, and yet in the second restatement, they were sort of uh, uh, ambiguously combined in the restatement sections in the second restatement. But we have the third restatement, and I was just going to mention that the third restatement, using these precedents that have come since '76, sort of comes out very clearly and says what the doctrine is, at least for purposes of summarizing the state of the law now in whatever, 2008, 2012, 2020, when the third restatement really is adopted by the American Law Institute. And so section 41 of the third restatement is titled Duty to Third Parties Based on Special Relationship with Person Posing Risks. And it says that special relationships giving rise to this duty to take reasonable care, and they have 4 different sections. And the last one is a mental health professional with patients, okay? And that doesn't tell you how closely defined the identity of the potential victim has to be. But then when you look at the comments, they talk about how the vast majority of courts have adopted a standard involving the language or the concept of readily identifiable.
And sort of conversely, has there been any concern, or was there concern expressed following the decision that this would interfere with the therapeutic relationship between therapist and patient, and that if the patient became fearful that what he or she said to the therapist might be broadcast to somebody, the patient would either decline seeking treatment or not be honest? Was there any thought about that?
Absolutely. If one were to go back and look at the dissent was very, very vigorous, and it was essentially, well, it was based on numerous arguments, but a leading argument that the dissent raised was one that was presented to it by the lawyers for the defense. But the lawyers for the defense were also in an alliance with civil society organizations. Different professional organizations representing the mental health professions were very engaged in the amicus brief writing process, and the California Supreme Court received amicus briefs from the American Psychiatric Association and other allied mental health professional organizations, as well as university professors, all of whom said 2 things, and I'm going to focus on one of the 2. They were focused on, in part, the cost to society and the cost to individuals themselves were the therapeutic relationship compromised by the fear that confidences would be communicated to law enforcement, and also not just the confidences would be communicated, but then also that there would be practical consequences that one might actually find oneself detained or subjected to involuntary commitment proceedings that one wouldn't have otherwise been subjected to had one kept one's mouth shut. So the idea that you have this very, very large pipeline of information that is flowing towards mental health professionals in the state of California every day. You think about the tens of thousands, if not hundreds of thousands of people who seek mental health treatment in California every day, or in New York, or any state. And there's going to be a very sort of small number of those people who are engaging in ideation where they're going to act on a violent threat that they are articulating in the course of treatment. A very tiny percentage, we know that. And then one wonders about the very large number of patients who might not articulate all sorts of projections and ideations that would not lead to violence, but they're afraid to articulate them because they might be under the impression that consequences will flow back to them that will be very bad for them, and they just won't be candid with their therapists or with their psychiatrists. That was the concern that was raised, and that's allied to another concern. So when you read the dissent, when you read the amicus briefs, there are these two concerns. One is the one I just articulated, which is a kind of almost put things in the balance, like how much is the life of the potential victim who will die worth versus the loss of therapeutic benefits to the thousands and tens of thousands of people who might change the way they speak to their therapist. I mean, really, that is a kind of crude way of putting it, but that in some sense was what the amicus briefs were asking. Mm-hmm. And the second thing that they were also saying was a little different. They were saying that all assumes that the mental health professional actually can sort between the likely threats that will lead to real world violence and the statements made by patients that are not going to lead to real world violence. The whole question is whether or not we're going to sort of have a total confusion of false positives and false negatives. And that's the second point, because if you don't believe that there is a actual capacity on the part of the recipient of these words, if you don't think that the therapist or psychiatrist can actually usefully distinguish between the threats that are not going to lead to violence and the threats that are going to lead to violence, then it's even just kind of, then the other question about balancing costs and benefits is moot, because you can't even actually trade between costs and benefits, because you can't even anticipate which acts are going to be costly and which acts are going to be not costly. Mm-hmm. So there were two arguments made by the amicus briefs, two arguments made by the dissent, and they are connected, but they are distinguishable as well. And I just want to make sure that they were both understood when I give you this answer.
Yeah, it seems to me that this might put the therapist on the horns of a dilemma, so that if, for instance, a patient comes in and says, I hate my boss and I might just kill him. On the one hand, if the therapist warns the boss and the patient is fired, the patient has been harmed. On the other hand, if he doesn't warn the boss and the patient kills the boss, the therapist has failed to protect the boss. How are they supposed to weave or balance those two?
Well, I mean, I think that, first of all, the consensus seems to be in the last, now we're talking about 40 years now, the consensus seems to be that the capacity for mental health professionals to anticipate or predict with accuracy whether or not the patient's words are part of that tiny minority, that tiny minority of threats that are likely to lead to real world violence versus the vast majority, the huge vast majority of words that are simply reflecting fantasies and projections. The consensus seems to be that while there's no perfect capacity to predict, mental health professionals seem to be better at this than the average person, okay? So this puts the mental health professional in a tough position because they have a talent which they're proud of, which they've gained through training, and which is really valuable to society, of being able to mitigate a real risk more so than, say, by just random guessing. So that's the first thing, because if that weren't true, then the whole question of the duty would be, as I said before, it would be moot, right? But it's not moot, because mental health professionals, it turns out, are actually better than, say, the average person. That doesn't say that they're especially good at it. I have no idea, and I don't think anyone has an idea how to measure their sort of success rate. It's not like measuring the ability of a person shooting at a target to be able to sort of hit the target. We just don't know. I mean, there's going to be a lot of still false positives and false negatives, but the mental health professionals make fewer false positives and false negatives than lay people. Okay, so this says, okay, given that mental health professionals are in a strategically advantageous position to try and do two things simultaneously: treat people and make them healthier, and also, when it arises, save people and make them not dead. How should they trade off between these two goods? And the answer there is tort law has traditionally always, and this might be a very clumsy way of answering your question, but tort law has always had a hierarchy of values. That hierarchy of values has always placed life and physical health and integrity at the highest point. So we don't let people protect property at the cost of making a mistake and making a careless mistake or even an intentional act in order to protect property against the cost of someone's life. We always put the thumb on the scale to deterring conduct for any other value that might imperil life. And here too, I think it's been, I think, relatively well accepted by the mental health community that life is a very, very unique good. And while the health of their patients and the health of the community in terms of mental health is also a good, that if you have to come up with crude rules that come up with a hierarchy of what is going to get the benefit of the doubt, protecting life and the body is going to be at the top of that hierarchy, and promoting mental health and the welfare of the community through mental health treatment is going to be lower, not worthless, but lower. Because again, a lot of things have to be remembered here. First of all, the duty is triggered only when the mental health professional is able to predict with some reasonable certainty that there's going to be violence. And secondly, the consequence of that duty, which might be to make a phone call to the boss, as you put it, or it might be to make a phone call to a third party who could engage in some kind of intermediate protection, like a outpatient order, or like a extra layer of protection by providing a security guard to stand at the entrance of a building. These things are not in themselves punishments to the directly, at least punishments to the patient. They are things which one would think are warranted if indeed the patient does pose a real threat to another person. They are costs that the patient bears, but they're costs the patient bears because they've already articulated a potential violation of another person's right.
Excellent. And so Tarasoff from 1976 was and remains an important landmark in American law.
Absolutely, and its significance goes also into directions which may not be of sort of as great urgency for the audience of this presentation, but also I should say that it is a masterful discussion about how, in general, a state Supreme Court, which is a common law court, is supposed to think about duty overall. If you read the decision, what you see is this magisterial review of the philosophy of tort law, where the court goes all the way back to a case called Heaven v. Pender, which is an English case from the 19th century, and says there is a kind of fundamental way of thinking about our duties to each other, which arises from our ability to think about risk as the ground of a relationship. And we impose on each other duties based on that relationship of risk. And then we only cut duty down, we only cut duty back for certain policy reasons. And one of those policy reasons might be, for example, the cost to society of allowing that duty to be enforced. And what you see is this kind of really interesting argument between the majority who want to have a duty and the dissent who doesn't want to have a duty on the sort of where the rubber hits the road on this policy question. Because what the minority, what the dissent does is it doesn't disagree with the majority about the theory of duty. What it does disagree with is whether or not ultimately the costs and benefits of having a duty in this class of activities, treatment of people for mental health, is so high that the duty should be suspended in this case. And what, for me as a scholar, it does is it raises an interesting question about democracy, which is, it's an interesting question why this conversation is being held among a handful of judges who, in California's case, have virtual lifetime appointments. They could be recalled under certain circumstances. Why isn't it being conducted in a state legislature? And in fact, what you find is that after Tarasoff, the whole question whether there is a duty relating to this class of activities, treating people with mental illness, is actually taken up by the legislature. And the legislatures of certain states, like Colorado, for example, decide to step in and say, well, we have a view about this trade-off, and this is what we think. And then they basically supersede state common law with legislation.
Interesting. Well, thank you very much, Professor Sebok. This has been really informative. Thank you very, very much.
You're welcome.